begin to analyze the background of this case, Siddharth versus State of UP. The appellant was stopped in FIR which was filed 7 years ago and he was granted an interim protection until the filing of police report. The appellant joined the investigation and charge sheet was ready to be filed. Section 170 of CRPC which provides that after the investigation, the officer in charge of opinion that there are reasonable grounds to believe that the accused has committed the crime, then the accused is to be forwarded to the magistrate who empowered to take cognizance for trial upon a police report from the officer. But the trial court in this case interpreted section 170 to mean that until the accused is taken to custody, the charge sheet cannot be taken into the record. Thus, the accused had to be applied for anticipatory bail, which was rejected and arrest memo was issued, prompting the appellants to approach the Supreme Court. So here the court observed after referring the various cases from different high courts, Supreme Court concluded that the purpose of section 170 was only to ensure the presence of accused when the charge sheet is filed. So Supreme Court further observed in the case Delhi High Court, which was the judgment of Delhi High Court in its motion versus CBI, dealt with the similar contention that Section 170 CRPC prevent the court from taking the charge sheet into record until the accused is in custody. Court further observed that personal liberty is an important element of constitutional mandate, and it further observed that the arrest may be made if the offence is grave and officer in charge believes that there is a possibility of accused absconding or if the investigation cannot be completed without the arrest of accused. So in this case, it observed the arrest is only made if the offence is grave or otherwise the officer in charge believes that there is a possibility of accused absconding of the investigation or investigation cannot be completed without the arrest of accused. Also, Supreme Court observed in the judgment which was delivered by Gujarat High Court in Deen Dayal Kishan Chand versus State of Gujarat. Thus, the High Court had observed that not accepting the charge sheet without the production of accused is not justified under any provision of law. Here in this case, it brings out the importance of right to liberty. The right to liberty has been at a very high pedestal by Indian Constitution. Importance of liberty highlighted by the Honorable Supreme Court in Nandini Satpathy versus D.L. Dani, where it pointed at creating a balance between the needs of law enforcement. According to this court, the protection of an individual from injustice and oppression has been perennial problem, and with the time of pendulum seems to be have swing in the favor of law enforcement. So this remarkable judgment places a personal liberty of an accused in given case on highest pedestal, and Article 21 of our Indian Constitution, it manifestly accords the supreme significance of right to life and individual liberty of citizens. So it is not obligated to take the accused into custody at the time of filing the charge sheet and producing him before the court in custody. Further, if the indicted is not accused during the probe and he is to be typically considered entitled to be released on bail, as no purpose would be served by denying the bail to a person who has not been arrested during the probe. This noteworthy ruling makes it relatively clear that nowhere does Section 170 of CRPC impairs any obligation of any count of an offence in charge to arrest each and every indicted at the time of filing charge sheet, which must be abided and stuck into the summation. Simply because an arrest can be made lawfully, it does not dictate that arrest must be made. Individual liberty and character of a person are important aspects of Article 21 of Indian Constitution, which provides the right to life and personal liberty. So therefore, the distinction must be made between the power to arrest a person and the justification behind the use of this power.
We are discussing about the case law Siddharth versus the state of Uttar Pradesh and another. And here the fact which emerges is that the appellant along with 83 other private persons were sought to be robbed in a FIR which was registered 7 years ago. And the appellant claims to be supplier of stone for which royalty was paid in advance to these holders and claims not to be involved in the tendering process. And here the similar person was stated to have been granted interim protection until filing of the police report. And here the appellant had already joined the investigation before approaching this court, and the charge sheet was stated to be ready to be filed. However, the main issue here is that the reason to approach this court was on account of arrest memo having been issued, and another issue before this court is that whether the anticipatory bail application of the appellant ought to have been allowed. And there are certain relevant judicial precedents quoted here, and the main ruling here cited is section 170 CRPC, in which states about the cases to be sent to magistrate when evidence is sufficient. If upon an investigation under this chapter, it appears to the officer in charge of the police station that there is sufficient evidence or reasonable ground as aforesaid, such officer shall forward the accused under custody to a magistrate empowered to take cognizance of the offence upon a police report and to try the accused or commit him for trial, or if the offence is bailable and the accused is able to give security, shall take security from him for this appearance before such magistrate on a day fixed and for his attendance from day to day before such magistrate until otherwise directed. So here the ruling reveals what sort of interpretation to be given while reading section 170 of CRPC. That is, it does not impose any obligation of any kind on the officer in charge to arrest each and every indicted at the time of filing of the charge sheet. And here cited several judicial precedents in which clearly quoted that about how to interpret the meaning of custody. That is, it does not contemplate either police or judicial custody. It merely connotes the presentation of accused by the investigating officer before the court at the time of filing of the charge sheet, whereafter the role of the court starts. So, in cases where no doubt arises in regard to the absconding of the person or about the non-appearance before the court, making such a custody mandatory is not essential. And also here regarding the main issue arises, that is merely because an arrest can be made lawfully, does it mandate that it must be made? As clear from the judgment itself that um, the personal liberty is an important aspect of our constitutional mandate, and the occasion to arrest an accused during the investigation arises when custodial investigation becomes necessary, or it is a heinous crime, or where there is a possibility of influencing the witnesses or accused may abscond. Merely because an arrest can be made because it is lawful does not mandate that arrest must be made. A distinction must be made between the existence of the power to arrest and the justification for exercise of it. So if arrest is made routine, it can cause incalculable harm to the reputation and self-esteem of the person. Also, it is in violation of the basic human rights aspect also. So if the investigating officer has no reason to believe that the accused will abscond or disobey summons and has in fact throughout cooperated with the investigation, there is no need to make such a custody compulsory. And insisting on arrest of an accused is a prerequisite formality to take the charge sheet on record in view of the provisions of section 170 of CRPC is contrary to the very intent of section 170 of CRPC. And in the present case, when the appellant has joined the investigation has completed and he has been robbed in after 7 years of the registration of the FIR. There is no reasonable justification for why at this stage he may be arrested before the charge sheet is taken on record. And further, the Supreme Court in Joginder Kumar versus State of Uttar Pradesh emphasized the need for a distinction between the power to arrest a person and justification to exercise it, because if an arrest is made a routine, it would cause irreparable and incalculable damage to the reputation and self-esteem of such person. According to all aforementioned factors, this present judgment sounds constitutionally valid. Same time, accepting the valid several other exceptional circumstances in which it is mandatory to eradicate injustice to the public interest, and also the safety and for the maintenance of law and order. Also, such arrest for minor prosecutions cannot be considered as necessary for the purpose of crime prevention. The detention of these arrested persons lead to a heavy expenditure on the maintenance of which definitely could be avoided. Also, if there is no sufficient evidences and reasonable grounds that concerned person has committed any crime, keeping mandatory to put an accused in custody will not serve any beneficial purpose for safeguarding the criminal justice system. as well as it violates the constitutional right guaranteed under Article 21 of the Constitution of India, as well as the basic human rights of a person who, without any reasonable grounds, being arrested. Also, when police submit the charge sheet, it is the duty of the court to accept it, especially in view of the provisions of Section 468 CRPC as stated in the case law itself. So, the judgment in present case that it is not mandatory to arrest each and every accused person during the filing of the charge sheet is fair, just, and reasonable. And it would also prevent the police from unnecessarily arresting the accused persons by virtue of Section 170 of the Criminal Procedure Code.